afternoon, everyone, and welcome to Brian Sebastian's Movie Reviews and More. Today, we have a very special guest. We have Mr. Marc Jacobson visiting us. He is an attorney who has been ranked the best attorney in the United States for the last 20 years by Chambers USA. His law firm, his name, Marc Jacobson P.C., specializes in entertainment law. What that entails is music, film, TV, and theater in the production, distribution, and financing of those productions. Cases familiar to some people might be the Elvis Pressley estate, the Duke Ellington case, George and Ira Gershwin. He's represented Shakira, James Brown. But most notably, we have Mr. Jacobson. He is a pioneer. He's an American hero. He's an icon. In 1998, he authored the Congressional DMCA, which stands for Digital Millennium Corporate Copyright Act. What that means is that it makes it a criminal act to produce and disseminate devices, services, or technology that evades measures that control access to copyright works. And before we begin our discussion, I just want to do a disclaimer for us in the room and for you listening that this is only for information purposes. There is no attorney-client privilege. So this is just for information, and please don't use what is said here in law or in court.
Well, let me can I just say something quickly? It's not that there is no attorney-client privilege, certainly, but I'm not going to be anybody's attorney in here. So
right, or out there.
That's funny. Oh, and Mark, co-host Terry Marie from Redondo Beach, California.
Hi, hello everyone. Hi, Sherry. How are you?
So welcome, Mr. Jacobson. Given that you're one of these high-powered, recognized attorneys in America, have you always been interested in law, or did something happen to you in your life that spurred you down that avenue? And specifically, what turned you on to entertainment law?
So it's a two-part question, but the answer to the first part of the question is yes, I've always been interested in being a lawyer. And what got me interested in being a lawyer is when I was a kid, we used to go to my mother's sister's house for Passover, which is a holiday coming up very soon. And there were dozens and dozens of people there, and it was filled with my uncle, my mother's sister's husband, my uncle, was a big lawyer in Jersey City, very prominent lawyer handling workers' compensation. And the people who came to the Seder were judges and lawyers and other people of influence. So I thought that was cool. And I really liked my uncle, so I thought I would be a lawyer. Then when I went to law school and I figured out I can make money watching TV, going to the movies, listening to music, reading books, and going to the theater, I said, I'm going to be a copyright and entertainment lawyer. That's how it came about. There's two steps. First step was debt fund.
Back when you were in university, did you ever think it would take on as robust of a ever-changing creation as it has been?
Impossible. It is extraordinary what's happened. What was really interesting, when I was the general counsel at Prodigy and I left, I was really at the very, very peak of knowledge at that point about the intersection of copyright and technology. There wasn't very many people who knew what I knew at the time, because I had written the Digital Millennium Copyright Act. I had developed contracts. And when I started in private practice, what would happen is I would get forms back from other people that were my forms. I had created them at Prodigy, and they had gone out into the universe, and then other people were sending to me as if they had adopted them, and I know that I wrote them. So I got a big kick out of that.
How long did it take you to draft such a groundbreaking act? Or did you act alone, or like, I'm curious.
Well, are you talking about the legislation,
yeah.
the DMCA?
Yeah.
No, that took about 2 years, and it was not me alone. It was a group. It was the general counsel of AOL. It was the general counsel of MCI. It was lawyers for ASCAP. We used to go and have meetings. It was Congressman Goodlatte who was running it. We used to go have meetings 2, sometimes 3 times a week in Washington, and it was a very large table of 16 people. And 5 of them represented users, 5 of them represented owners, and 5 of them were people who felt that they were either owners or users. And those were the really smart people, because they figured out that everybody's going to be on both sides very quickly. Of course, I was in the user side for Prodigy, and it went on and on and on. It took forever to get it done. So, but it was fun. I really enjoyed it. It was very challenging.
Mark, when you think of NAPSCAP, remember Sean Fanning, that whole era, the .com thing, music started to change.
I knew Sean.
What were you thinking about? Where did you see music going from there?
Well, it's interesting. Sean Fanning was the guy who invented Napster, which was really a means by which people could share files and not pay for them. It was really the beginning of the decline of the music industry. It was like 1998, 1999, and the industry took a nosedive because it was, what was interesting is there were senior guys who saw it coming, but didn't pay attention to it. There's a fellow named Doug Morris who was, I think he was head of Warner at the time. He just said, I'm not gonna worry about it. And basically the internet ate the music business. And so the business disappeared by about 50%. We knew at Prodigy that was happening. We didn't realize that it would happen as fast as it did, because Prodigy actually had set up a store very early on to sell CDs online. The download part was what really threw everybody. And I had started a company actually with a friend of mine called Spiral Frog, which had actually acquired the rights to Universal Music's catalog. We paid a very large advance, and we had the right to allow people to download those songs for free for 30 days, so long as they kept coming back and watching ads. And so it was an ad-supported model, which frankly, at the time, was the way TV worked, because cable was around, but it was still largely a free TV model. So it made a lot of sense, but it didn't work. And now you have, the reason it works for Spotify and other services is they have a paid tier on top. So the paid tier supports the free tier. Does that make sense? Mm-hmm. Did I go too far?
No.
Makes sense.
You know, I remember the little girl when I would rent movies, when you'd rent movies, and I remember it always said anyone who copied, and it was a Swedish law at the very end of the film, the copyright thing. Do you remember that? I'm not sure, but I always was curious.
No, it was definitely American.
Sorry?
It was definitely American.
I thought I saw that it said in Sweden or something, but with these copyright laws, is it a state by state, a nation by nation law, and where do you go if you were to copyright, or is there a better place, a tighter law if you needed something copyrighted?
So until 1978, there was a federal law and a state law regarding copyright. In 1978, the new Copyright Act, which substantially revised the then 1909 Act, basically said we're preempting all the state laws that are equivalent to copyright, and there will be one federal law of copyright. So now there is a US law, but copyright itself is what we say is territorial in nature. What applies in the US doesn't necessarily apply in Canada or France or Germany. There are lots of conventions, there are multilateral treaties, and there are common ideas that are prevalent throughout the world. Like if you own a copyright, you own the exclusive right to make copies of that work. So that makes sense. But what's interesting, for example, is in the US, there is no what they call making available right. So if I put up a library of movies on a website and they just sit there and nobody comes, in the US, you don't have to pay any royalties because nobody comes and nobody took it. But simply putting it up on the website in Europe implicates the making available right, and therefore a royalty is due for all of those. So there are differences territory by territory. The big thing we did for George and Ira Gershwin was, those of you who may know, George died in 1937 and Ira died in 1973. So what happened was, in the UK, music was treated as one copyright and lyrics were treated as another. So the music of George would go into the public domain in 1988 in the Commonwealth territories, because that's how they treated it. But the lyrics of Ira would stay protected for another 50 or 70 years. And the reason for that is in the UK, they didn't recognize joint works. Oops, joint works. So if you and I, Sherry, write a song together, we both own it forever. And now it'll last for 70 years after the longest one of us to live dies. But in the UK at the time, George had died. They were treated separately. And so that meant that George's music would go public domain and Ira's lyrics would not, which we were concerned about, representing the estate, that they could use his music for advertising that would be inconsistent with the image of George Gershwin. And so we convinced the collecting societies around the world to treat it as a joint work, and he got his revenue stream continued, which was basically millions of dollars a year.
You know, that's very interesting because when the world of rap comes in, all of a sudden you got everybody sampling James Brown stuff. And then the Tech 10-second rule comes in. And one of the reasons—
There's no 10-second rule. There's no 10-second rule. There's no 10-second rule.
Well, we kind of called it that, even though it wasn't that, if that made sense. We didn't sample anything.
Well, don't do it. You could sample, listen, the Beastie Boys got in trouble for sampling Yo Leroy. That doesn't take 10 seconds to say.
True.
So if it's distinctive enough, you can get caught and sampling. I tell my clients who are creators, just don't sample. It's not worth the effort. It's way too expensive. If you're a talented songwriter, just write your own songs. You don't need anybody else's help.
Mark, can you, I was listening to you on another, you were at a law panel and you were talking about the varsity law, about where cheerleader, you know, people were using music and things like that. And you had to kind of, even though they were claiming it's just for promotion, it didn't matter.
Yeah, that old argument that well, I don't have to pay for it because I'm giving you promotion doesn't work. It never works, because if I'm the music creator, I get to decide when you or whether you use my music. That's the deal. It's like real estate. I don't have to let you on my property if I don't want.
That happens. Oh, I was just going to say that's something that happens all the time with social media, with YouTubers, and that's always a conflict with people using other people's music.
Oh yeah, well, YouTube has set up like their own little law, which is very clever. If you create a video and you use some music in it, the owner of the music can decide whether to let you do it and not make any money, whether to let you do it and make money, which is what they call monetize, or they can make you take it down. So that's what YouTube has decided to do. They've created this automatic licensing process, and most people will do it that way, but you don't have to if you don't want to. You just make everybody take it down.
Yeah, well, it's kind of weird because even like I'll say on the TikTok, for example, with the music on there, they'll have, you know, artists will put their music out there to sample it. New artists are out there, but then it's weird because people will start, there's certain videos will just start getting pulled down for copyright. But how are you supposed to know which songs you're supposed to use and which you can't? You know, so it's kind of confusing with that way that works.
Well, the way those big social media platforms work is they try to get blanket licenses for everything. Yeah. Mm-hmm. So the right that gets implicated when you're doing a little TikTok dance to music is what we call the synchronization right. So you get the right to synchronize the music to your video image, and that would apply both to the recording, which the record company owns, and to the musical composition, which the music publisher or publishers own. Going back to your point about rap, Brian, I've cleared rights to songs with 22 publishers in it. So it can become quite the problem. Shakira's song, Hips Don't Lie, had 10 publishers in it, and I had 3 weeks to clear that song. But so the problem is, if you're a small publisher and you own a very popular song, you may not want to grant rights to TikTok or Triller or any of those guys to use your song. So you'll be busy taking it down. Most publishers say, oh, you can have it, just pay me.
Well, and I was wondering about that, you know, with not in entertainment law perhaps, but say, for example, you go to court and you win a judgment against someone. And they often say, you know, getting the judgment is the easy part. It's collecting that is the difficult part. So in technology now, if you won a lawsuit for your music and your everything that you've registered, trademark? Is it easier to take it down now, or is it still a domino?
It's not about taking down. I have a client who got a judgment against a very prominent band that had a very big hit in the 1970s. And so what we're doing is we're making the people that have to pay him royalties, like the record company, like the publisher, like BMI, like Sound, we're making all those people pay my client. So it's not as though you're taking something down. The song is still out there and we all listen to it. But the revenue is going down to my client because he owes my client a couple $100,000.
Oh, okay. So if, say, for example, you have your image or your likeness and you copyright it or you trademark it, and somebody uses it, it's similar to if you created music and then.
Yeah, likeness, name and likeness rights are very different than copyright. You and I have a right to privacy, okay? You can prevent someone from using your name and likeness simply by saying, don't use it. But once you are a public figure, your ability to control that starts to go away a little bit. Donald Trump just last week wrote a letter to the Republican Party telling him that he didn't want him using his name to raise money, which is a little ridiculous. There's nobody more prominent than the president, but that's what he's trying to do.
So in that situation, is there anything a public figure may do to protect themselves or guard themselves?
Well, sure. Someone like Serena Williams, who's very prominent, she licenses her name and likeness for millions of dollars. So, you know, she can do that. If you put her name on something, she gets millions of dollars. But Barack Obama won't. Donald Trump might, because he's a different kind of guy. But it really depends on the individual. But yes, name and likeness rights exist. Right of privacy exists in every state. There are a number of states that have what we call a post-mortem right of publicity, which means that after you die, if you were a public figure, you still have rights. New York just adopted that statute, and it can last for 40 years. Because Elvis was in Tennessee, Tennessee adopted a statute, and those rights last forever for famous people in Tennessee, but only 40 years in New York. California has it, Indiana has it, depends on the state. And it's different around the world as well. So it changes from country to country and state to state.
Hey, Mark, you got a lot of artists now selling their music rights, which I think is very smart. What's your feelings on that? Do you think more artists should jump in because it maybe helps them tax-wise, or since they're not touring and it may be another few months? Do you think that's a smart idea?
Well, it's a very complicated question. I mean, I think to answer, if I'm a new artist and I am approached by a publishing company, they will always come over to me and say, I want to buy your publishing rights, which is half the value of the copyright, including the right to control it. And my advice to my clients is don't sell. If they're going to pay you X, whatever they're going to pay, you know it's worth more, because they're not going to pay you full value, because otherwise they wouldn't make a profit. So hold on to it. And lots of my clients held on to their rights for a very, very long time. Some of them got in tax trouble and they had to sell them, and they used that to satisfy the tax problem. That's one situation. But the current environment is such that the prices of catalogs are disproportionately high to their historical value, because there's a higher demand, because there's higher usage, because the number of streaming and other services are there. Plus, interest rates are historically low, so the cost to put the capital together to buy the catalog is low. Finally, in the US, currently, when you sell your catalog, you're paying capital gains rates, which is 15 or 20%, whereas if it was not capital gains rates, you'd be paying 35%. So it changes dramatically the value of the sale. Do I think people should sell? It depends on their personal situation. If you're a 25-year-old artist and you're just starting, don't sell. Unless you are 100% certain that that catalog of songs is the absolute best catalog of songs you're ever going to write, which of course is ridiculous, because you're going to write more songs. It doesn't cost you anything to write a song. Just go write another one. So, but there's no reason to sell them, which goes to the value. If the four of us get together and write a song, it may not be that we each take 25%. It may be that I only get 5% because I didn't contribute that much. But if we agree that my share is 5% and you guys split the other 95, however you want to split it, then it doesn't matter. It's fine. Because the next song I'm going to write, I'm going to make sure that I get 90% because I know that's my better song.
That reminds me of when Prince at the time. Remember when he left, I'm not exactly sure the label, and he wanted to get more rights and things like that. Was he successful in changing things when he was alive about artist rights and worth?
Yeah, he made a great deal after he left Warner Brothers. He got a gigantic advance. I had made a comment in Billboard about the article, and the lawyer for Prince called me up and yelled at me for making the comment. But I don't remember what I said, but I remember getting yelled at. But yes, he did change it. And really what happens today is very different. Today, it used to be you'd sign with a record company, and then you'd make a publishing deal, and then you'd make a merchandising deal, and then you'd make a touring deal. But today, you make a record deal with a record company, and typically that record company then takes a piece of your merchandising, your touring, and your publishing, because the record company is the engine that drives everything else. And when the Napsters hit and the business took a nosedive, the record company said, hey, we better take a piece of all this other stuff or we're never going to make our money back, which was nonsense, but that was the position they took.
You got this great line on your website, songs are always being consumed. I love that line. And what it makes me think of, I marched in the drum and bugle corps and marching bands, 70s, 80s, right up until I think like 90, you could play almost anybody's song. And the authors and those writers would be there cheering those bands and drum corps on. Because of the internet now you can't play their songs. And it gets, you know, unless you paid like $20,000 for something. It was like really sad.
Well, I'm not so sure that it's that expensive. There's a new company out there that's gone to all the major publishers and is trying to get the rights, particularly from marching bands and things like that. I represent Varsity. Sherry mentioned it before, and they do a lot of cheerleading stuff. So they have to be very careful about rights too. But you can get those rights. They're not cheap, but they're not really expensive. And it really depends on how you use it. This particular company was foolish enough to sue Beverly Hills High School for their unauthorized use of songs, and they lost at the trial court, and then they took it up on appeal, and they lost on appeal. So they've made some bad law for themselves.
Wow.
Mark, in these types of cases, do you prefer to have a jury or just a judge?
Oh, I don't go to court.
No?
No.
You're that one guy, one phone call, that's all it takes.
No, I just negotiate deals. I know how to go to court. I used to do trials when I was a very young man, but no, I don't do it. So jury.
No jury?
Not for me. I don't know. Sometimes it's better to have a jury. Sometimes it's better to have a judge. Depends on the case. I suppose if the case is very complicated, I'd want a judge, because judges in theory can pay more attention. Jurors will just go right over their head. Depends. It's really, when you go to trial, you're really talking about competing stories, right? The way that a juror or someone or any of us actually connects with something is because of the nature of the story. You have to have empathy for the character has to evolve, and the result has to be something that we're all satisfied with. That's what a really good trial lawyer does. I like to do that in movies. I don't like to do that in courtrooms.
Mark, how cool is it now that biopics are the rage? You know, we saw this coming on the movie side of stuff, and we've been cheering it on for years. But, you know, I'm thinking of the Bee Gees. You know, it was one of the best documentaries I ever saw. Kenneth Branagh just decided to do a feature film on the Bee Gees for Paramount. How difficult is it to get most of those rights if, say, one band member is holding out? Is it a fight? Is it a challenge? Or does it get outruled? How does that work? It's
always a challenge. Always a challenge. Rocket Man, right, with Elton John, they couldn't get rights to all the songs.
Yeah.
I'm actually producing a movie based on the songs of Boyce and Hart, who wrote lots of songs for the Monkees, like Last Train to Clarksville and things like that. So we happen to know Tommy Boyce's widow. We happen to know Bobby Hart. They're both my clients. And we came up with the idea of doing a biopic about them, which is a backwards way to do a story about the Monkees without buying rights to the Monkees, because they wrote the song.
When you're doing a movie, is it safer legally for a writer to do it based on a true story or a biography? to spare lawsuits? Is that
it's such a complicated question? It really is, and I think I have 4 matters in the office right now that are addressing that issue. One of them is based on a famous painter from the 1950s, and my client was approached with the idea by someone, and she read the script, and the script was terrible. So my client went out and bought rights to a book, hired another writer, and wrote a new screenplay based on the book and ignored the original screenplay. So that original writer is making a claim now saying the new script is based on it. I literally wrote a demand letter today about someone who couldn't come to terms with a client on a true story. And we're making it clear that whatever they wrote belongs to my client because we own the underlying rights to the true story. I mean, it happens all the time. There's no clear answer. The best position that I could say to people is don't start working until your contracts are signed and the money is paid. That's it. But that's always the case. It's, you know, people go into the studio and they say, oh, I work with this producer and he's saying he owns the track and I wrote the song. You know, it's always a mess. I put 2 kids through college on that complaint. So
what about when people write a movie? And then I don't know if it's just for clickbait or if it's just for an attention. When all of a sudden, out of nowhere, someone says, that was based on me. I'm gonna, are they tossed, or do they have merit to make it to court?
Everyone is different. We did a movie called Conviction many years ago with Sam Rockwell and Hilary Swank. And there was a dirty cop in the movie. And we didn't get his rights. And he never filed a complaint. But somebody else who was also a true character did file a claim. And we wrote back to the lawyer and said, no, this is true. So you got no claim. And she went away. It depends. It just depends.
And if you were to, say you were to write a story or license things like that, I guess, is there a state in America or a country where you have tighter laws for the creator, or like where would be, I'm thinking of like complex trust, you know, sometimes they say the Canary Islands, you know, you're tighter from lawsuits. I'm curious, is there like a looser state versus a tight state?
Well, certainly not states for copyright purposes in the US, because as I mentioned, it's all one law, but it also doesn't matter because the international treaties, the most popular international treaty, or maybe the most important international treaty, is the Berne Convention. And what it says is that when your country is a party to this treaty, you have to treat foreign nationals that come to your country the same way you would treat your own nationals. So a French person who comes to the US and brings a copyright suit has to be treated as if she was an American. And vice versa. An American who goes to France and brings a lawsuit in France has to be treated as a French national. So it's like that. There are different remedies. In the US, for example, we have what we call statutory damages and willful infringement damages, which in shorthand is punitive damages for copyright infringement. Most other countries don't have that. So if there is an infringement in the US, people will want to come here so they can beat you over the head harder. But it depends.
Mark, we got about 5 minutes left. What was it like to be you being locked down in New York doing what you do? Did the work stop? Were you?
I work at home. I've been working at home for 4 years. There's almost no difference. And because my business is what it is, last year was the best year I've had in a very long time. And the reason for that is my clients went about their business to get ready for the end of the pandemic. So they bought rights, they hired writers, they wrote songs, and they're ready for stuff to happen. And I'm already getting ridiculously busy because the stuff is coming out.
Are there, with the, you know, the extreme popularity of Zoom, StreamYard, things like that, are there new issues, new laws to be made down the road with, you know, this stay at home for the past year? Where
yeah, actually what's happened a lot is that, and particularly in the music business, a lot of artists have gone out and started streaming their performances. So you can pay $5 and come stream a show, and you keep the $5. The challenge comes when you record that show. So if I am playing my songs, and I record a Rolling Stones or a Beatles song, I can't later sell that recording without the Beatles or the Rolling Stones permission. So that's where it gets very dicey. The other thing that's happening is one of my clients has developed a software where the four of us could be talking like this, and I could hold something up and you can click on it and go buy it right away.
But Mark, that's one of the reasons why I never wanted to have movie trailers on our YouTube channel or any of that music stuff on our shows, because I would have a lot of them, my friends' music on, and I never wanted to have to deal with that as things were changing and evolving. Especially we have a Spotify, we have Pandora, we have Clubhouse now, and all of a sudden people are doing extra things. And where are the guidelines? Because no one knows. Well, like, you will know, but most people don't know.
It's hard. You have to take a minute and figure out what's happening. I mean, I had a guy call me up the other day, a lawyer, said, what do I do? And, well, you got this layer and that layer. I mean, it gets very complicated. It can be. But I've been doing it so long, it's very easy for me.
Yeah. Terry, I can see you thinking about something.
There's a mole.
No, I'm just listening.
Terry, Mark, what would your advice be for attorneys coming out wanting to join your profession now? What would you tell them to do? What would be your advice?
If they can't get a job in entertainment law, which is quite likely because it's very, very competitive, I would encourage them not to become litigators. I would encourage them to do corporate or real estate work so they know how to make conclude deals and make transactions happen. I would encourage them to go to Volunteer Lawyers for the Arts so that they could volunteer and do that work. And then I would encourage them to join the organizations of the fields in which they're interested. So they can join the Grammy organization or other songwriting organizations if they're interested in music, or they can join the Independent Feature Project if they're interested in film, and go to the seminars, go to the cocktail parties, shake hands with someone, tell other lawyers you're available to help them out if they have a conflict of interest, and don't expect the person you talk to be the one who hires you. Never pitch that hard. Tell them about yourself, make them go away and remember you, so that when they think of the friend who has a problem, they say, oh, you should call this guy, because I just saw him the other day. He's young, he's hungry, he's interested. That's how, if you're very relaxed about it, it comes back very easily. I get asked that all the time. That's my standard advice. It works. I know a woman who took that advice. She became a senior in-house lawyer at HBO. So
it can't go wrong there. Sherry, we got time for one question. I know you got one left.
Mark, occasionally you teach at law school, and I'm curious, what types of subjects are you most popular or really wanting people to learn from?
The students want to hear war stories. They want to hear what happened here, and they want to hear what happened there. I'm actually teaching a class right now. I'm an adjunct at Montclair State University, and I'm teaching legal and business aspects of independent film production. And we're talking about from the beginning, from acquiring the rights, forming the company, raising the money, hiring the people, getting the locations, doing the distribution deal, all that. It's complicated. It's hard. I do it all the time. It's very routine for me, but the students are struggling. I didn't realize how hard it would be for them.
And I've listened to your lectures, and you have excellent delivery. So I recommend anybody, if you can catch one of Mr. Jacobson's lecture or see on YouTube his panels, do, because they're very informative, and you do speak well to people at our level.
Well, thanks. That's you can find all that on my website at marcjacobson.com.
Yes. And it's MARC, but we'll post it for people.
Okay, great.
And Mark, I want to thank you. Wow, I could listen to you for a couple hours because you're informative. And
tell my wife.
But it's important because artists, everybody needs to know these things because they just simply really do not know. And so, do you want to take a chance to get into
action?
No, just do it. So I got to end with that. Marc Jacobson, thank you so much. Sherry Nelson, thank you as usual. And Terry Nonstop, Marie, thank you so much. I'm Brian Sebastian. This is Movie Reviews and More. I always say this: if you see someone without a smile, please give them one of yours because the world needs it. And we will see you next.